Okay, so if everybody will make sure that you're muted so that we don't get any background noise, and I hope everybody can hear me. So this is our legal update, and I've updated it just a little bit since I did it at the end of January, because there's been a couple of developments I wanted to share with you. I know that I'm also speaking on Friday at a QB event down here in Albuquerque, and I've had the question as to whether or not I'm covering the same material. I will cover a couple of these topics in more detail on Friday, and maybe a couple of new things as well. So let's get started because we have 2 hours this morning, and those 2 hours go by quickly, as we know. So I want to talk to you about some revised forms, NMAR forms, 1106, which is our exclusive listing agreement, 1206, which is our buyer broker agreement, 5143, which is our resolution addendum. So as you know, we have an objections form, 5141, and then we have the response form, which is 5142, and then we have a resolution addendum, which is 5143. And a section of the revisions we made in 5143 are also carrying over to 2101, which is our price modification seller credit form. And then we have a compensation information sheet and a buyer broker termination agreement. And those are both two new forms that will be released. I'm going to talk about case law updates and just an update on some discriminatory covenant updates regarding what they're doing about discriminatory covenants. Endorsement testimonials, we'll talk about those, and then some hotline questions. And as I think about things, I might just talk about other things as well, because there seems every single day new issues come up, and I want to share with you guys. So before we get into the changes to 1106 and 1206, which is our listing agreement and our buyer broker agreement, I just wanted to remind you about the case, the Sitzer versus National Association of Realtors and other defendants case, which is kind of, set us on our head, so to speak, and has created the need for some of these changes we've made to these two forms. So as you all might recall, the Sitzer case came out of Missouri, and it alleged that commission rates were too high, and that buyer brokers are being paid too much, and that the NAR rule that required that brokers put an offer of compensation in the MLS was creating all of this, these high commissions and buyer brokers being paid too much. All of these allegations stemmed from what they allege to be the co-op broker commission rule. So if you are a realtor owned MLS, you have to follow NAR's policy on MLSs. And one of those, that policy was, up until just recently, that policy is that if you were going to put your listing in the MLS, it had to include a co-op broker commission, some offer of compensation being made to the buyer broker. Now, as we all know, there was never any specific amount being dictated. So it could be as little as $1 and it could go up from there. And there was no number that was being dictated by NAR or by the local MLSs. However, there was some dollar amount required. Since the verdict, which came out in October, where a jury, not a judge, a jury found that NAR and the two co-defendants liable for keeping agent compensation artificially high, the jury awarded the plaintiffs in that case nearly $1.8 billion. Now, you probably have heard the term closer to $6 billion. And the reason you hear that term is because it's an antitrust case. And under antitrust law, the Sherman Antitrust Act, you can get up to 3 times actual damages. So that's where you hear the number of 6 billion. Now, that number, that ruling is going to be appealed by NAR, of course, and we're not going to have, we're not going to know what that appeal looks like for a number of years. I mean, it just takes a really long time for that to happen. But we are going to see an appeal come out of that. On January 8th, NAR did ask the federal judge to enter a judgment as a matter of law in NAR's favor, basically saying that the jury didn't have enough evidence to find the way they found. And asking as a matter of law to set aside the jury's verdict. That has not been granted at this point. But there will be an appeal if they don't set aside the jury's verdict. I anticipate, of course, that NAR will be appealing that so that we have, we have another kind of opportunity, or NAR has another opportunity to make some arguments that they don't feel they were ruled upon correctly at the district court level. Now, we don't have a written opinion out of that case. I've been asked a couple of times if we could look at that, a written opinion, but because it was a jury verdict and not a judge's opinion or a judge making the decision, we don't have an actual opinion to look at. It was a jury verdict. So if we end up at the appellate court, we will certainly get something out of the appellate court, something in writing. Just, as a result of the Sitzer case, as soon as that verdict came out, plaintiffs all over the nation started filing lawsuits. I just heard about another one yesterday in Nevada, but I can't even keep up with them at this point because they're being filed so quickly all across the nation. They're being filed against MLSs, they're being filed against brokerages. In order to call this an antitrust issue, you have to tie various entities together that are not otherwise related. So you have to tie things like the National Association of Realtors with the local MLS, with the local brokerage. And the allegations are that these three players that are completely separate players have been colluding or conspiring, by having this rule, this co-op broker commission rule requirement, have been colluding and conspiring to inflate these commissions. And so ever since this happened, we have just seen across the nation, and I knock on wood right now, that we haven't seen it here in New Mexico yet, but we've seen a number of complaints being filed against local MLSs and brokerages. And as you can see here on the screen, this is just, another example of more cases that are being filed every day. I think that the plaintiffs' attorneys are trying to take great, before this thing gets appealed, and in the event that it should get set aside on appeal, or the lower court should be overturned, they're trying to take advantage of this to file these lawsuits now while these things are pending. So they're happening all over the United States. NAR is trying to consolidate these cases. So we're dealing with the same exact fact pattern all over the place. So these plaintiffs that are filing these lawsuits are all home buyers. There was been a couple of lawsuits with home buyers, but all of these lawsuits that I've been talking about right now and the Sitzer case all are made up of home sellers. So they're all sellers that are banding together and filing these actions, and the subject matter of all these lawsuits are exactly the same. So what NAR is trying to do is trying to get these things consolidated so that you're not wasting basically all of the court's time litigating the exact same issue over and over again. And instead it can be litigated once and be done. So they're working on that. One of the biggest class action lawsuits with regard to the subject matter is a $200 billion case against NAR, Compass, EXP, World Holdings, Redfin. You can see the list of brokerages here on the screen. And NAR and the defendants wanted to wait for this particular lawsuit to be heard until the Sitzer appeal had been decided, because again, the appellate court could make a decision in the Sitzer case that the lower court or the jury in the case of in that case was actually wrong in what they and how they applied the law and how they determined based on the law, their determination based on the law, and they could overturn that decision. And so what NAR said was, could we wait to litigate this particular case until the Sitzer appeal has been heard and decided? And the court in this particular case said, no, we will not grant a stay, and we are going to allow this case to move forward. So it makes that $1.8 billion verdict look rather small because they're estimating damages on this particular case at $200 billion, which is a number that I can't even wrap my head around. I mean, that's just incredible. But it is moving forward. So we also had another kind of blow the other day. There's another lawsuit called the MLS Penn lawsuit, and they named several franchisors, Anywhere, which owns a number of brokerages, Remax, Keller Williams, Home Services of America. Interestingly enough, about this Penn lawsuit, NAR was not named in this Penn lawsuit. It's the same subject matter. They just didn't name NAR in this particular lawsuit. And some of the parties entered into a settlement agreement with the plaintiffs in this case. And part of that agreement was an overhaul of the commission policies, where MLS Penn did say that they would eliminate the requirement that listing brokers offer some co-op broker commission. And they were also going to pay $3 million and cooperate with the plaintiffs against the remaining defendants in the lawsuit. But what happened the other day is when the MLS Penn entered into this settlement agreement with the plaintiffs, and they submitted it to the court for approval of the settlement, the DOJ weighed in on the settlement. And DOJ meaning the Department of Justice, and they said that they didn't like the settlement agreement. One of the things they said was that, the class plaintiffs were not going to get much money, somewhere between $3 and $5. And what is so unfortunate about a class action lawsuit, it consolidates all of these plaintiffs into one lawsuit. So you're not litigating again the same issue over and over again. But the problem is that the class action attorneys end up getting very, very wealthy on these things. And the actual plaintiffs that are involved in the lawsuit end up getting very little money out of it. So that was one of their complaints. But the main complaint that they had was that they not only, because again, MLS Penn had already decided that they would no longer require that there be a co-op broker commission entered into the MLS. So it was going to be up to the listing broker after, of course, talking with their seller and making determinations as to whether or not they wanted to offer a co-op broker commission, whether they even wanted to put one in there. So the option was open for a listing broker to put nothing in there if that's what the listing broker and their seller had decided to do. And I will note that after the Sitzer verdict came out, right before I think it came out, NAR came out and said that 0 is a number as far as co-op broker commissions were concerned. So even though all this time and over all of these years, there was this requirement under the NAR rules that some amount be put in there, even if it was just $1, NAR kind of took a different position and said, no, 0 is a number too, and we'll allow 0 in there. So, most of the MLSs across the nation, ended up changing the rules to say, you don't have to put in a co-op broker commission if you don't want to. However, like I said, in this DOJ case, they've gone a step farther than that. And they not only don't want them to dictate or require any amount to be entered, they actually want to prohibit listing brokers from offering any co-op broker commission in the MLS. That's what the DOJ would like to see happen out of this lawsuit. Their argument is that unless you prohibit it, that listing brokers are still going to be pressuring sellers to put offers of compensation in the MLS. And we're not going to, the DOJ is alleging that it's not going to change the way business is done. I will be honest that up in the Pacific Northwest a number of years ago, long before these lawsuits ever came to be, there is a MLS up there that is not a realtor-owned MLS, so they didn't have to follow NAR's rules, and they had eliminated the requirement for co-op broker commissions to be entered. They could be entered, but they didn't have to be entered. And of course, they were never, of course, dictating how much. And really, things didn't change drastically as a result of them not requiring co-op broker commissions be entered into the MLS. They were still, a lot of brokers were still entering them, and we know why, right? We know that in a lot of cases, buyers are not in a great position to come to the table with additional funds. They're already coming up with money for down payments and inspections and surveys and whatever other fees are associated, all the other fees that are associated with purchasing a property. And for them to have to come up with even more money to pay a buyer broker agreement, that doesn't, that eliminates a lot of buyers who might want to buy somebody's house if they have to compensate their own buyer broker. And so it really it behooves the seller and puts them in a better position to be able to offer that co-op broker commission through the MLS. So that's one less expense that the buyer has to deal with. But again, the DOJ is alleging that, if you don't not just eliminate the requirement, but actually prohibit listing brokers from putting a number in there, that it's not going to move the dial. Now, what they also say about that is that, in the event that a buyer is in a position that they can't pay their own buyer broker, then when they make the offer, and we'll talk about this a little bit more as we talk about the buyer broker agreement, they can put in their offer that the seller will pay the buyer broker X number of dollars. And for those of you who kind of work between the commercial world and the residential world, you'll notice that in the commercial purchase agreement 3101, our commercial purchase agreement, there's a provision for who's paying the brokers, both who's paying the listing broker and who's paying the buyer's broker. And so you would see that same kind of language. Right now, it would have to be on an addendum to 2104 because we don't have that provision in 2104, our residential purchase agreement. But you would put it on an addendum that the seller's agreeing to pay the buyer's broker X number of dollars. And so that's the way the DOJ thinks it should be handled, that the buyer should be asking the seller to pay their buyer broker if that's necessary and required. But again, that the MLSs actually prohibit the listing brokers from putting in an offer of compensation. Now, this is really interesting, and it'll be interesting to see how this plays out. The DOJ doesn't get to determine, how this plays out. They get to weigh in, and that's what they've done with this with their opinion on the settlement agreement. But of course, the court can completely dismiss the DOJ's position on this and just go along with what's already been negotiated between the plaintiffs and the defendants that settled in this case. So they don't have to follow what the DOJ does. if they do follow what the DOJ does, if they do, say that, no, we're not going to accept a settlement agreement unless this provision is in there, and if MLS Penn actually does incorporate this provision into their rules, how that's going to play out with NAR will be an interesting to see, because again, if you're a if you're a realtor owned MLS, you have to follow NAR's rules. Now, NAR has let up on the rule that you have to put a co-op broker commission in there at all, because 0 is now a number. But it does not, of course, provide anything. NAR rules do not provide anything with regard to prohibiting a listing broker from putting in, actually an MLS actually prohibiting a listing broker from putting some number in the MLS. So, I don't know what NAR is going to do with that if MLS Penn decides that they want to move forward with this and they're willing to actually sign on to this requirement. And I honestly can't even imagine that they would do that. So, and the pendulum has certainly swung, because on one level, they allege that that the requirement was creating the problem, and now they want not just the requirement to go away, but an actual prohibition to be put in place. So this is going to be huge to see what the court does with this DOJ opinion that they've weighed in on the settlement, and what they do with that, and how that impacts not just MLS Penn, but of course NAR rules on MLSs, and then how that trickles down to every MLS, realtor owned MLS in the nation. So a lot to be watching for on this particular issue. What we've taken away from all of these lawsuits, including this new DOJ issue, is a couple of things. That buyer broker agreements, listing agreements, of course, we've always used and have been very important, but buyer broker agreements are very important as well. And that we are encouraging everybody to start using buyer broker agreements. And I know that in the past in New Mexico, and probably nationwide, not just here, we have not used buyer broker agreements very often. And I think part of it is you get a little, it's a little intimidating to put a form in front of a buyer and say, we're committed to one another. And, on the flip side of that, I'm not sure, that you haven't even worked with this buyer. And I'm not, a lot of brokers say, hey, I don't necessarily want to be tied to this buyer. It's not just the buyer not wanting being tied to me. I don't necessarily want to be tied to this buyer. And when you sign a buyer broker agreement, you've created a contract where you've agreed to work with them and they've agreed to work with you. And so neither one of you can just walk away from that deal. You can always terminate that deal, right? You can always agree to terminate that deal, but you can't unilaterally walk away from the deal. And so I know that there are everybody kind of enters into these buyer broker agreements with a degree of trepidation and concern. But what we've taken out of all of this is that they are important to establish with your broker, your buyer, a couple of things. First of all, what you expect to be compensated and how you expect to be compensated as a buyer broker. And I think that those conversations haven't been had enough in the past. I mean, I think that a lot of times buyer brokers aren't real clear about how how buyers are not clear about how buyer brokers get paid and what the buyer broker expects to be paid if you don't have a buyer broker agreement in place. So the buyer broker agreement clears all that up. It makes it very clear what the buyer broker expects to be paid and how they'll get paid. So they're very important forms, and we're hoping that with some revisions that we've made to the forms, and with these lawsuits that are coming out, that everybody will start using the forms. So let's talk about 1106 before we get into 1206. And 1106 is our exclusive listing agreement, and we've made just a few changes to this particular form. First of all, I wanted to point out before we get into the compensation provisions, because we've added this to 1206 as well, the informed consent requirement. So you'll note, I'm sure you guys have seen in the 2104 cover page 2, because we added that some time ago, a provision where the buyer is agreeing to be to dual consent, meaning that the broker is representing both the listing side of the transaction and the buyer side of the transaction. When we revised those cover pages about a year and a half ago, we kind of beefed up that language, and we did so because of this standard of practice 1.5. So under the code of ethics, the realtor code of ethics, it says that realtors may represent the seller / landlord and buyer / tenant in the same transaction, but only after full disclosure to and with informed consent of both parties. And I highlight the term informed consent because informed consent is different than consent. Consent is just saying, yes, I consent to the representation, but informed consent is where you explain what it means to consent to this dual representation, and you get the other party to acknowledge that they've been informed about that, what's associated with that dual consent before they agree to it or don't agree to it. And so this is why we've kind of beefed up the language both in 1106 and in 1206. So on the listing agreement cover page 2, we have had added at the bottom of the page there some dual consent language, and it does require the sellers to sign off. And we say that by their signature to this at the bottom here, at the bottom of the page, their signature is evidence that they consent to the dual representation. But of course, when we're dealing with dual representation, one of the main issues that comes out of that from the seller's perspective is what we find in this box in the middle of this page. Because as we all know, we have tried desperately in 2104 to stop sharing reports and inspection reports with the seller. We used to, back in the day, we used to send those things over every single time you make an objection to anything, right? Or anytime that you're terminating. But a number of years ago, we changed that. And I hope that everybody on the Zoom today is up to speed on the fact that we no longer just send reports over to the other side. Instead, what we do is we send, if we're objecting and asking for repairs, we ask for a specific repair. We send the specific part of the inspection report that goes with that request, right? So we're not sending the whole report. We're only sending that particular part of the report that goes along with the request for that particular repair. In the event that you are terminating a contract based on inspections, or you're asking for some kind of monetary concession, so you're asking them to do a price drop, or you're asking them to do a seller credit of some sort, then you send nothing over to the other side, absolutely nothing over to the other side. Okay, so I hope that everybody's up to speed on that, because I've talked about in the past, I've talked about, and it is still the plan moving forward. We have been a bit derailed with some of our forms issues, and I'll talk about that in a moment. But we are moving in a direction where there are some consequences, unfortunately, to the buyer in the event that the buyer's broker just sends that entire report over. And I've been talking about this for about a year and a half, at least a year and a half, maybe 2, about those consequences. Because right now, because buyer brokers do not work as agents, they simply work as transaction brokers. What they do can't necessarily be attributed to their buyer. So their buyer isn't necessarily responsible for what their buyer broker does. That's one of the beautiful things about transaction brokerage opposed to agency. So currently, if a buyer broker sends over an inspection report when it wasn't requested by the seller, because the seller can always request it. If they get a section of the report, or they get a termination, or they get a price reduction, and they say, hey, I want to see the entire report that this is based on, we have a form in the library for that. And all the seller has to do is request the entire report. And the seller signs off that that's what they want, right? And so if you don't receive that form from the seller, not from the listing broker, again, listing brokers aren't working, most of them are not working as agents, they're working as transaction brokers. So once again, this needs to be coming from the seller, this request. But if that request doesn't come in, the buyer's broker isn't supposed to be sending that report over. If they do send that report over, then they have not assisted their buyer in conforming with the terms of the contract. But again, whether you can attribute that action on the buyer broker to the buyer, there's an argument to be made there, because again, that buyer broker is not working as an agent. So the so-called fix for this, because we have been dealing with this for a number of years and buyer brokers continue to send the whole report over even if the seller hasn't requested it, is a provision that I've talked about before that we may be putting into the purchase agreement in the future, that says that in the event that the buyer broker does send the entire report over when the seller has not requested it, that would act as a forfeiture of the buyer's earnest money in the event that the deal terminated. So if there is the buyer's asking for a number of repairs to be done, and they send the buyer broker sends the entire report over, and they can't negotiate those repairs and come to an agreement, normally the buyer would get their earnest money back, right? Because if they don't come to resolution by the resolution deadline, the contract terminates, the buyer gets their earnest money back. But if that buyer broker has sent that entire report over to the seller without the seller asking for it, it would result in the buyer losing their earnest money under that scenario. Same is true if the buyer was just terminating. You're not sending anything over per the contract. But if you did, as a buyer's broker, send the whole report over when you terminated, and again, normally the buyer would get their earnest money back if they terminated timely, then it would result in the buyer losing their earnest money under that scenario. So, it's a scary, kind of a scary proposition, a little bit draconian. I will agree with you on that. This is the way they handle it up in Washington, and they have the same provision in their purchase agreement. And I did speak with my counterpart up there, and I've talked about this before. And I said, gosh, I can't believe you guys put that in there. And I can't, what's been happening as a result of that? And she said, well, initially, buyer brokers were having to write earnest money checks. They were having to write earnest money checks to their buyers because they had lost their buyers' earnest money when they sent that whole report over. But that didn't continue to happen because the buyer brokers stopped doing that. They started conforming with the terms of the contract, and they stopped sending the report over unless the seller asked for it. So it did stop the behavior, which is why the forms committee and two times the forms committee has decided to move forward with this, and 2 times the executive committee has decided to move forward with this. So the plan was to actually roll it out this year, but it didn't get rolled out this year because of some forms issues or forms administration issues that we're dealing with right now. But it is still planning, it still is in the work. So, even without that kind of, approach to this, draconian approach to this, all of you guys should be adhering to the terms of the contract and helping your buyers adhere to the terms of the contract and doing what the contract says, which once again is only sending the whole report over if the seller asks for it, and only sending the sections of the report in the event that you're objecting and asking for repairs. So just follow that line. But going back to our screen here, one of the big things about dual consent is that if you are representing both a buyer and a seller in a transaction, and the buyer gets an inspection done, then you as a buyer's broker are likely going to have all of that information. The buyer is going to share it with you and ask you, what should we do about this? Should we ask for this? Should we ask for that? Should we do a price reduction? Should I terminate? They're going to want some input for it from you. So if the deal ends up falling apart, even though perhaps that report never went to the seller, so the seller doesn't have knowledge of that report and doesn't have all that knowledge about their property, you as the listing broker do, because you also represented the buyer in the transaction, right? And so now you, as a broker, have an independent obligation to disclose those adverse material facts to the next buyer, even if your seller didn't get the report and isn't aware of those adverse material facts. So that's the conversation when you hit this section of cover page 2 that you have to have, the conversation you have to have with your seller is, okay, and before you consent to this dual representation, before you say, yes, it's fine for me to represent the buyer in the transaction as well, let's talk about what that means, especially with regard to this adverse material facts information. And have that conversation with them. And then if they say, fine, I understand, you're going to know all about these ugly things about my house, even if I don't. So you're going to go have to share those things with me and with the next buyer. I get that. Then by all means, seller signs off on this, and now dual consent is fine, and you can represent both of them. In the event that the seller doesn't agree to that and doesn't want you also representing the buyer, then of course the seller's not going to sign this page right here. I will also add, and it's not up on your screen, but we also have added a provision in 1106 that tells the seller whether you as a broker are willing to do dual representation, because a lot of brokers, they don't want to be put in this position. They don't want to represent both a buyer and seller for various reasons. And so you guys will have an opportunity in the listing agreement to say, I will or will not do, a deal where I represent both buyer and seller. And of course, if you as a broker say, I won't do it, then this section right here is completely irrelevant. So if you get to this section, because you will get to this section first before you get to the section in the 1106 where the broker gets to say what they will do, then you would just, have the conversation at this point. Listen, we don't need this point. This section right here on cover page 2 is irrelevant because I will not do dual representation. I will not represent a buyer in the same transaction that I'm representing you in. So you'll be able to just, move past this. And then when you get to that section of 1106, of course, you'll mark that you will not engage in dual representation. So that's a big change to 1106, because we really want, again, informed consent, not just consent, but we want the seller to be fully aware of what they're consenting to. So we also added to 1106 this buyer broker access to property. So as you guys recall, in 2104, our residential purchase agreement, we say that a buyer, once they're under contract, cannot just go onto the seller's property just because they're under contract, right? So they can't jump over the back fence and start peering through the windows just because they have a contract on the property. The only way the buyer can come onto the property is if the seller or the listing broker has given the buyer the permission to do so. And so this is where we solicit from the seller the authorization for the listing broker to tell the buyer's broker that they can come onto the property, right? And so we've added this section. So that's the kind of counterpart to the 2104 that says, buyer, you can't come on unless the seller or the listing broker has given you permission. And this is where the seller gives the listing broker permission to give the buyer and the buyer's broker permission. And then we get to the compensation section. And what we've done here is we have tried to explain, do a little bit better job at explaining how compensation is paid to listing brokers and buyer's brokers. I'm sorry, I think if I either skipped a section here, let me see if I can go back. Give me 1 second. I should be able to go back, but I'm not sure I can. Because I skipped to the compensation to buyer's broker section, but there's a section right above this which simply explains how brokers get paid. So it talks about how listing brokers get paid, obviously through the listing agreement. It talks about how the MLSs work, and what we did put in there that we didn't have before is that MLSs do not require, it's here, you can see it's here. It's important to note that MLSs do not require listing brokers to make an offer of compensation. And I guess in the listing agreement, we've incorporated it in this paragraph, so I don't need to go back. It is incorporated into this paragraph. So we're explaining, the sellers are fully aware that what they're paying their listing broker through the listing agreement. But here we're explaining to them how buyer brokers get paid. So typically, you're putting it into the MLS. Typically, there's an offer of compensation made in the MLS. But what we want to really hit home with our sellers, and this is part of the conversation you're having with them, is that not only do MLSs not require you to put any offer of compensation in there, but in the event that you do put an offer of compensation in there for the buyer broker, the MLS is not dictating, nobody's dictating, not local MLS, not realtor associations, not the New Mexico Real Estate Commission. None of those entities are dictating how much is put in there. So, again, it could be as little as $1. It could be anything more than $1. It's completely whatever the seller has agreed to share, how the seller has agreed to share, the seller and the listing broker. Now, what's also important here to note is that you as a brokerage can have a policy, right? A brokerage can have a policy on what they charge as far as commissions are concerned within that brokerage and for all their associate brokers. And they can also have a policy on how they share commission. So your policy could be, we always share 50-50, whatever we're getting as far as a commission is concerned. Our broker policy is to always share that, 50-50 with a buyer broker. So in the event that that's your policy that you've made within your brokerage that impacts your brokerage, your associate brokers within your brokerage, then of course you can state that to your seller. You should absolutely state that to your seller. This is what our brokerage policy is on what we charge for commissions, how we share commissions with our fellow brokers. You're supposed to share all of that during this process with your seller. Nothing that's happened in the law prohibits you guys from having those kind of policies. What the law prohibits is for one brokerage to walk down the street and have a conversation with another brokerage, but hey, how about we set commissions at this amount of money? And how about we agree that our policies are going to be to share commissions with co-op brokers in this particular way. So it's when two competing entities, which are two competing realtor brokerages, of course, get together and make a decision about how they're going to set their prices, or they're going to share their commissions. That's where you get into hot water, right? That's where you get into antitrust issues. So fine to have it within your brokerage with your associate brokers, because they're all agents of the brokerage. Not fine to go talking about it and coming up with plans of compensation with outside brokerages. So this is the section where you get to explain all of this to the listing broker. And this, going back to what I said earlier, is the place where you would have those conversations with your seller about whether or not they want to enter a co-op broker commission in the MLS and why that might be beneficial to them. But going back to what I said about, some buyers are not in a position to come up with extra money for broker commissions. And so putting an offer of compensation in the MLS may open your pool of potential buyers, right? Because you're not limiting them only to buyers that can afford to pay their own brokers. You're opening it up to all buyers. So these are the conversations that you have to have, again, emphasizing that no one's dictating how much you offer unless it's a brokerage policy. And then again, you have to make it very clear if you have a brokerage policy on this, that that's your brokerage policy. This is not the way everything is done in the business of real estate in MLSs. This is your brokerage policy, and another brokerage might have a totally different policy on co-op broker commissions. So making it very clear that it's just strictly to your brokerage. But this is where you have that conversation with your seller, and you let your seller decide whether or not they want to offer co-op broker commission. And if your policy is, we always offer co-op broker commissions, that's our brokerage policy, and your seller says, I'm not going to, I don't want to, I understand the benefits, the potential benefits associated with that, but I don't want to do it. Then if you're not willing to set aside your brokerage policy, then they're going to go down the road and they're going to find a brokerage that doesn't have that same policy. And that's, that's competition, right? I mean, that's the way the marketplace is supposed to work. Then paragraph 3 is the seller paying the bonus to the buyer broker. And that is nothing new, that's been in there. So this was created when you would see in the MLS, and you still do to some extent, that if a buyer broker it brings a buyer within, there might be some stipulations, a full price offer within the first 2 weeks of it being on the market. There may be other stipulations. The seller is willing to pay the buyer's broker a bonus of some sort. So in addition to whatever the listing broker's offered to pay the buyer's broker, that co-op broker commission, the seller is willing to pay some additional bonus. And so this language has been in here. It really needs to be modified, perhaps modified. Well, no, probably for the 1106, it wouldn't need to be modified, but the form itself, all we had to do to this form is change the title of it, and it's form 4660, and it was called the seller's I think it was called the seller's bonus to buyer's broker form. So exactly what you see here, seller's bonus to buyer's broker form. But what I changed it to say is seller's compensation to buyer's broker form, because this form can also be used now with the revision that I just made. And it's probably not live in the libraries yet, but it will be. It can be used for a seller to pay a buyer broker directly in the event that the seller is willing to do so. So in the event that the listing, when you sit down with the listing broker and the seller sit down, and the seller says, I don't want to offer any compensation through the MLS, I just don't want to do it, right? And then the buyer broker has a great offer that they want to bring forward, but there's no offer of compensation. The listing broker, you can go to the listing broker, you can ask the listing broker, hey, could you please offer some compensation? I see 0 in here, but is there a possibility we could negotiate something else and enter into a broker to broker compensation agreement for some different amount? And that's perfectly permissible. And the listing broker says, no, I can't, I won't do it, I can't do it, whatever they want to say about that. And so the broker may say, well, is your seller willing to pay, a broker commission directly to me? If that was the case, and you have to go through the listing of broker because they have a listing agreement, so you can't do an end run around the listing broker. But if you said that to the listing broker and they said, well, I'll take that to my seller, and the seller said, yeah, fine, I'll pay the buyer broker some percentage, you could use this form. And it would be a direct contract between the seller and the buyer's broker for that compensation. And I like the idea of that, because yes, the buyer can always put that in the offer. But as you all know, you're not parties to the purchase agreement, right? So in the event that the seller didn't pay you, and it was provided for in an addendum, if you're using 2104, that the seller was going to pay you as a buyer's broker, and you had to sue on that because you didn't get paid, you'd be suing as a third-party beneficiary to that contract, a very intended third-party beneficiary, because the language is there. And I'm confident I'm pretty confident that would play out, that there would be no problem with you getting paid on that. But I like the idea of you guys being able to contract directly with the seller. I like that idea better. I don't think it's always going to present itself, honestly, the opportunity for you to contract directly with the seller. But if it should come up, that you could contract, and I'm not talking about unlisted properties, because we have a compensation on unlisted property form that is separate that we'll talk about in a minute. So this provision right here, or this form, would be used when there is a listing broker. The listing broker said the seller will compensate, even though the listing broker is not compensating the buyer's broker, the seller is willing to do so. You guys could enter into, the buyer broker and the seller could enter into this agreement. So anyway, just change of name, seller's compensation to buyer broker, and it's already it's in the library right now as seller's bonus, but it's being changed to seller's compensation. And then we have an acknowledgement box. And I know that we had done away with kind of acknowledgement boxes and initials in the middle of pages. But we felt like this particular topic about commissions and how everybody's getting paid, given all of the landscape and all of the things that have been occurring, was important enough that we needed to have the seller acknowledge that they have had this conversation with the listing broker. They are fully aware of how compensation works. They understand that neither the MLS or local, state, or national association of realtor or any kind of national or state or local law is dictating how how much is charged or how the co-op broker commission works. And we have them acknowledge it in this box in 1106. We also made some changes to 1206, which is the buyer broker agreement. Again, we're hoping this gets a lot more use as a result. I modified what you see right now. It's out in the library on this dual representation. Was causing some confusion, and so I did modify this section, and it has been approved by the executive committee, and it is going over to the vendors. And this is because right now, what it says is it says this, but it just says it in such a way that's a little confusing with the signature part. So I wanted to talk with you about how you will see it as soon as these revisions get made. Now, I just give you a quick update on what's happening on a forms level at NMAR. We have 4 forms providers. We have 2 that are considered membership benefit providers, which is SkySlope and Transaction Desk. So in the event that you are you're a member, you're here today, you get to choose from one of those platforms and you don't have to pay anything extra to use one of those platforms. We do ask that you choose one or the other because we do get paid or charged per user on each of those platforms. So if you're bouncing back and forth between the 2 of them, we're going to get charged twice, right? Once from each platform, but you can choose one of those platforms to use. We also have an agreement with Zip Forms where it's not a membership provider. So it means that you will have to contract with them directly, but they do have a license to use our forms. So they can upload all our forms into their platform, and then you can contract with them directly and pay them directly to get those forms. We have currently a similar situation with Dotloop. They have a license agreement right now for the use of our forms. We were thinking about terminating that agreement with them because it's very hard to manage the number of platforms that we have already. But we had a number of users who wanted to continue to use them, and we are trying to work through some issues so that they can do so. So currently in the moment, Dotloop is one of those providers, and they may be in the future if we can work out negotiate some contracts with them. But again, that would require the user to contract directly with Dotloop to take care of the charges associated with that, but they would have our forms on the platform. So when we release a form or a change to a form to all the vendors, they all get sent to the vendors at the same time, but they don't all pop up at the same time. They will pop up on one vendor at one point, and 2 or 3 weeks later at another one, and maybe a month later on the other one, and we have no control over that. And that's part of the problem with having all of these multiple vendors. So you as a broker, for example, if you hear about something that's been changed in a form, and then you get the form and it's not been changed yet, then that means that that particular buyer broker who submitted it, for example, is not using a platform where that change is been posted yet. And we harp on them and we stay on them and we try to get them done as quickly as possible. We have provisions in our contracts with them that say they have a certain amount of time to get things posted. Unfortunately, sometimes they just don't get them posted as quickly as we would like, and we're just waiting for that. So right now, you will see dual representation language. I want you to thoroughly read it so that you can work with the language as it's currently written. But I think when it gets cleaned up with this language, it's going to be easier. So you have 2 options under the way this is worded now. So I think the way it's worded now, currently in the forms library, is by signature to you're consenting to dual representation. But if you don't consent to dual representation, you have these 2 options right here, but then you don't sign. You just check the box, but you don't sign. And I think that's what's a little bit confusing. So in the future, with this section, you're going to sign no matter what. You're just going to make an option as to whether or not you consent or you don't consent. So you have to remember with buyer brokers, you're dealing with a little bit different issue on dual representation, because if you're working with a buyer and the buyer says, you know what, I don't want you to represent the seller on the transaction, that you're representing me as a buyer. And if you have a perfect property for them that you happen to have listed, It's not like you're going to go to the seller and terminate your listing agreement so you can work with your buyer, right? That's not going to happen. So we have to figure out another way to deal with that. If you have a buyer who says, no way, I don't want you representing the seller and me on the same transaction. So if they opt for A, under this scenario here, buyer consent to dual representation, obviously they're saying it's fine. If they opt for B, then there's a couple of different choices. And again, what's out in the library right now has this same language, but they're only signing if they consent. If they don't consent, they're just marking one of these boxes and there's no signature provision. And that's what's changed in the way we've handled it here. Here, you're going to sign no matter what. You're just going to mark the box whether they consent or don't consent. If they do not consent, a couple of options. The first option is that you, as the buyer's broker, will refer them to another buyer broker. So you could refer them to another broker in your office. You could refer them to a broker outside your office. You, as the buyer broker, get to decide who you're going to refer them to. And then the buyer will still, all of the compensation provisions and will still apply under this buyer broker agreement. But you're going to work out with the buyer broker who you referred this buyer to how you guys are going to split that co-op broker commission. So the listing broker has put a listing in the MLS and they've made an offer of compensation. And now they're going to be sending their buyer to another broker to represent them in the transaction. And the two brokers are going to work out how they're going to split that co-op broker commission. Okay, so that's option one. Option two is you as a broker are going to release this buyer as to these broker listed properties, which again, we define as, obviously properties that the broker has listed. You're going to release them from this buyer broker agreement completely so that they can go off and find their own broker and work with whomever they want to work with. And you are not, and this is important, you are not going to make any claims that you're the procuring cause of that sale, because that will allow that other buyer broker to collect any co-op broker commission that you offered in the MLS. Right. So another buyer broker is not going to want to get involved in that in the event they're going to have to get into a procuring cause, dispute with you, the listing broker, on who gets that co-op broker commission. They're not going to want to touch that. Right. Even if you release the buyer, they're just not going to want to get into that. So you are saying here, you go ahead and work with whomever you want to work with, and I am not going to make any claims for procuring cause. So if I made an offer of compensation in the MLS, then that other broker can collect that compensation. So those are the options in the event that the buyer does not consent to the dual representation. And like I said, right now, if you go to the library and you look at the 1206, what you'll see is the same language, but it's going to say that you sign if they consent, and if they don't consent, then you're checking a box, but there's no signature. Okay. And we change that on what's coming out, and that's in front of you, where they're going to sign no matter what, and it's going to be a matter of checking the appropriate boxes. In 1206, we also created this whole section again on compensation and explaining to buyers how compensation is paid. And again, more education, more transparency, because again, this has been the subject matter of a lot of these lawsuits. It's just that there's no transparency and nobody knows how buyer brokers get paid, and it's some big secret, and that nobody wants to talk to buyers about it. So this whole section right here talks about the MLS, and that there may or may not be any compensation offered in the MLS. MLSs are not requiring compensation because, again, that's the way things are at the moment. Right now, there's no prohibition of putting any kind of compensation in there, but they are not requiring any kind of compensation. We also talk about FSBOs. There may be certain situations where there is nothing in it isn't in the MLS, and it may not be in the MLS because it's a for sale by owner. It could not be in the MLS because it was, an office exclusive situation. It could be not in the MLS for other reasons, because it's commercial property or vacant land, and that doesn't fall under clear cooperation. So it may not be in there for that reason. What I want to point out here, which is really, really important for those of you who are not aware of it, is that if there is an offer of compensation made in the MLS, it has only been made to the other participants within that MLS. So if you are not a participant in that MLS, you can't take advantage of that. So you might have found a property up in Santa Fe that is just perfect, and you're an Albuquerque broker and you're not a member of SFAR and you're not a member of their MLS, And there was an offer of compensation made in SFAR's MLS, but you as an Albuquerque broker can't take advantage of that offer of compensation. So you have got to get a broker-to-broker compensation agreement in place with that listing broker before you bring an offer, or you're not going to get any compensation out of that. You're not going to take advantage of that compensation. Now, if you have a buyer broker agreement and you can't collect from the listing side or from the seller, then your buyer is signing up to pay you. That's what this whole form is about, is they're signing up to pay you. But if you don't have a buyer broker agreement, so your buyer hasn't agreed to pay you, you're not a member of that MLS, you haven't gotten a co-op broker commission in place, a broker to broker compensation agreement in place with that listing broker, you could have been the procuring cause of that sale. Absolutely. You brought the buyer, but guess what? You're not getting paid by anybody in that scenario. All right. And that's happened a number of times. And I cannot emphasize that enough so that you guys are aware. The offer of compensation is only made to other participants in the MLS. Use a broker compensation agreement. This is another provision we added, which I think is so very, very important given these lawsuits. Again, what is as a buyer broker, what is your expected compensation? What do you expect to get paid? I think it's very important to establish that for your buyer right out the gate. This is what I expect to get paid. Because again, going back to competition, right, and the whole idea of competition in all of these lawsuits is that if you have a certain expectation of compensation that's up here, and your buyer's thinking, well, I can't pay you that much, right? And I don't know if I'll be able to collect that much from the other side. I'm going to go down here to this other brokerage and I'm going to see what their expected offer of compensation or expected compensation is, because it might be lower. And then I can afford to pay that, or I can maybe, it's a better chance I'll get the seller to pay it because it's not as much as this brokerage over here. Again, this is competition. This is what this, all these antitrust lawsuits are about. And so this is very important to establish what your expected compensation is with your buyer. And this is where you get to do it. And then B says that you're going to do everything that you can do to collect that compensation from the listing side or from the seller. So seller, because it's a FSBO, or seller, if you're listing, if the listing broker is allowing you to deal with the seller directly on compensation issues, or the listing broker, if they're not, and you're just dealing with the listing broker, you're going to do whatever you can do to collect that from that other side of the transaction. But in the event you cannot, the buyer is signing up to pay you. They are signing up to compensate you. Okay. And once again, we have a box because once again, we feel like this is very important for the buyer to acknowledge that you have explained, you have taken the time as a broker to explain how brokers get paid, and how the co-op broker commission works, and how the buyer's on the hook in the event you can't collect it from the other side. And we have them initialing this box saying that they understand all of that and that you've had that conversation with them. And then the next section is compensation earned and due during the term, and we do have a protection period in there. So in the event that you have a buyer broker agreement, you show the buyer a piece of property, your buyer broker agreement expires, the buyer goes back and buys that piece of property. This protection period will protect you for whatever period of time you guys have put in here, right? Whatever number of days. Now, what's important about the protection period is that it does expire or it does terminate early in the event that the buyer enters into another buyer broker agreement with a different buyer broker. And that's exactly how 1106 works as well, you guys. You have a protection period in 1106, right? So if you're representing a seller, your 1106, your listing agreement expires, and then they sell the property, to a buyer you introduced them to, a week later. After this expiration of their listing agreement, you still get compensated if you have put something in here for the protection period. But I want to emphasize with the 1106 and with this 1206, they both, the protection period terminates early if the consumer enters into another exclusive agreement with another broker. So another listing agreement with a broker, in this case, another buyer broker agreement with another broker. I will also point out for those of you who, again, work in the commercial world and also work in the residential world, that is not the way the commercial listing agreement works. The commercial listing agreement actually requires the seller to pay the broker, even if they enter into another exclusive listing agreement with another broker. It does not end the protection period early. And that means that the consumer is required to actually carve out those people in that next listing agreement. So it works differently in the commercial setting. If you guys are working between the two listing agreements, be aware of that. This is the same box. I'm sorry, it's just a duplicate of the last slide where we were asking for the buyer to confirm that they received that. I talked a little bit about 1606 earlier when I talked about how the standard of practice does prohibit a buyer's broker from using an offer to purchase to renegotiate an offer of compensation. And this is the key language here, that a listing broker has made in the MLS. So in the event that there's been an offer of compensation in the MLS, and let's say the buyer's broker wants to be paid something more than was offered in the MLS, the buyer's broker is prohibited under standard of practice 16-16 from putting in the offer to purchase that the listing broker will pay the buyer broker something more than what they've offered in the MLS. That is what this prohibits. So what it does not prohibit, and this is important, just as important as what it does prohibit, is what it does not prohibit. It does not prohibit a buyer's broker from going to a listing broker and saying, you offered X number of dollars or X percentage in the MLS, but my expected compensation, this is what I expect to be paid in this, is something higher. Would you please adjust that and pay me something more? And if the listing broker says, sure, I'll do that, then the parties need to enter into a broker-to-broker compensation agreement, adjusting that offer of compensation. That's all perfectly fine. This also does not prohibit a buyer from asking a seller in a purchase offer to pay the buyer broker commission. So the buyer can say, gosh, I don't have a buyer broker agreement, right? And there's been no offer of compensation, and I want my buyer to get paid, but I'm not in a position to pay him. I will ask the seller if they'll pay my buyer broker, or I have a buyer broker agreement and I am going to be on the hook to pay my buyer broker if the seller won't pay the buyer broker. So I'm going to ask the seller if they'll pay my buyer broker. So either one of those is fine, right? The buyer broker can go to the listing broker and ask if they'll reconsider what they've offered. That's fine. Or the buyer can ask the seller to pay their buyer broker in the offer. That's fine too. Again, so be clear on what 16-16 says, because in our 3101, our commercial purchase agreement, where the parties are negotiating the compensation for the brokers, a lot of times residential brokers will say, how is that even allowed? Well, we're not talking about what the listing broker is going to pay to the buyer's broker. We're talking about whether or not the seller is going to pay the buyer's broker, whether the buyer is going to pay the listing broker. We're working all that out between the parties in the agreement, and that's perfectly permissible. I'll also just note that in at least the metro area, the way the commercial brokers work in the metro areas, they don't typically put their commercial listings in the MLS. They advertise them on a platform that doesn't have a compensation provision. So they're not talking about compensation in any of the advertisements or things like that. And that's why it has to be dealt with, it is dealt with more frequently in the actual commercial purchase agreement itself. We also have a new form called the Notice to Unrepresented Buyers, because guess what's come out of this fun thing? A lot of buyers don't think they need brokers now. The idea that now they have to pay their own broker, they've decided they don't even need a broker. Now, I know from a listing perspective, I know what you guys are thinking. You're thinking, I'm going to have to do twice as much work because there's no buyer broker involved, but I don't represent the buyer. And it's very important for unrepresented buyers to understand that you don't represent them, right? If that's what they have affirmatively said. Now, if they haven't affirmatively said that, and that's why this is a great form to use to really hit this home, because what you don't want is to not be representing the buyer and have them think you're representing the buyer, right? So if they really have insisted, because if a buyer comes to you and doesn't say they don't want to be represented, then you're dual representation, right? And we're dealing with dual representation, informed consent, all the issues that we've already talked about. But if you have a buyer who comes to you and says specifically, I do not want you to represent me in this, I can handle this myself, I do not want you to represent me. You as a broker still have to provide broker duties. So you're doing that. You're explaining to them that this is, that I owe you all of these broker duties in Section A, these top 5 broker duties. I owe the totality of these duties to my seller. So I'm going to be doing all this for my seller, but I'm only going to be doing these things for you, the buyer. So you have to give them broker duties and explain that. You also, in the second part of this page 2, we have important notice to buyer. So we're telling them that, you understand I'm not representing you. You understand that I only owe you the top 5 broker duties and nothing more, right? And you understand these are things I'm not going to be doing for you, providing you with opinions and advice, assisting you in evaluating a counter offer, assisting you in drafting offers and counting offers, providing you with any kind of relevant market information. Don't ask me for that. I'm not going to provide you with information related to any contractual duty you may have under the contract. I'm not going to assist you in meeting deadlines. I'm not going to assist you in setting up any kind of inspections, right? I'm not going to provide you with information regarding service providers or these kind of things. So the second part is very important. You're telling them exactly what you owe them, and you're listing a bunch of things that you are not going to do for them, because again, they are an unrepresented buyer, and that's what they've chosen to do. So if you get a buyer who specifically says, I don't need you to represent me in this transaction, you need to be using this form, because you need to make it very clear to them what's happening. In the event that there should be some kind of complaint filed against you with the real estate commission, hey, you didn't do all these things underneath the second set of broker duties, section B, you want to be able to say, no, they specifically asked me not to represent them in this transaction, and this is the form they signed acknowledging that. So make sure you're using this form if you end up in that scenario. Otherwise, you're representing them. And if you're representing a buyer and a seller in a transaction and everybody's consented to that, so it's okay to do, then you owe both sides the totality of those broker duties, not just one's, just not the top 5, all of those on all of them, right? Again, this is the second part of the buyer broker form, or the unrepresented buyer form, telling them that you're not going to be representing them in any of this. We also made some changes to the compensation on unlisted property form. It's changed, just kind of formatting a little bit. And we're trying to make it a little easier to use, because again, with all of this attention, I think what we're seeing, we're already seeing consumers who think they can handle this stuff without brokers, and so they're trying to move in that direction. So if you're dealing with an unlisted property, a FSBO type situation, we made some revisions to this. Again, name of sellers, buyer, the broker and the brokerage, the property. Does this agreement apply to any buyer that the buyer broker should bring, or does it apply only to a specific buyer? Because maybe you have a specific buyer for the property, and so it's just this one specific buyer. The following buyers are excluded from this agreement, meaning the brokerage would not be entitled to compensation if they bring them. So they may say, the seller may say, I'll compensate you for anybody you bring. If you bring me a buyer and this thing results in a sale, I'm going to compensate you, but I may exclude a couple of people because they've already come to the house and they've already looked at the house, and I'm not going to pay you if they come back and buy it. So you may use A and C in conjunction, right? You wouldn't use B and C in conjunction, but you could use A and C in conjunction. And then the compensation that you expect to be paid, and that the seller is willing to pay you, the protection period. So again, if one of these buyers that's been identified in paragraph 4 comes back and buys the property during the inspection period, then you would still get paid for that sale. The term of the agreement, and then we have a bunch of disclosures that we have to make, right? Lead-based paint, we're telling them about that, and then we have some generic information, mediation provisions, attorney fees and costs. If they don't pay you, you end up in court, you get and you prevail, then you get your attorney fees and costs covered by that. We talk about fair housing, giving them a little information about how they can't discriminate. Counterparts just means that you can execute it, they can execute the exact same agreement, and even though both signatures aren't on one form, as long as those two agreements look exactly the same, they make one form. You get in law and venue, we've seen this, it's, wherever the property is located, that's where you guys agree to take this to court if you have to. So anyway, these are all our provisions that we have in all of our agreements. So this form has been updated a little bit, and hopefully you will always use that. Because in New Mexico, and I think I might have a slide on this, you guys can't get paid unless somebody has agreed to pay you. So if there's a co-op broker commission made in the MLS that you're a member of, then of course you can get paid through that, and you go to arbitration if the listing broker doesn't pay you. And again, you have to be part of that MLS. They will throw you into mediation before you go to arbitration. So, and if mediation doesn't work it out between the two of you, you go before an arbitration panel to work it out. But if you want to get paid directly from a buyer or a seller, you've got to have an agreement in place, right? So you've got to have a compensation on unlisted property. If it's unlisted, you've got to have a listing agreement from a seller. You got to have a buyer broker agreement. Otherwise, you cannot collect from a consumer without a signed agreement. So 5142 is our resolution addendum. We made a few changes to this that I want to point out. This language didn't, the intent of this language didn't change really. It did say all repairs shall be completed by an appropriately licensed professional. But what we meant, but we don't feel like it was very clear, so we've changed the language, is if the law requires that the repair be done by a licensed professional, then it will be done by a licensed professional. Because if you're dealing with a handyman type issue that doesn't require you to have any specific licenses, then the intent is not to say you have to hire a licensed contractor to do something that doesn't require, under the law, a licensed contractor to do the work. So we wanted to make that clear because, I think that all repairs must be completed by an appropriately licensed professional. That was not the intent, is to make sure that a licensed person is used every time, only when it's necessary, given the type of repair that's being done. Okay. This other section was modified as well, and a couple of things I want to point out on this. So we did just have the seller agrees to credit, so much, and we want to be clear what that's being credited towards. It's closing costs, including but not limited to prepaids, inspections, warranties. And we added buyer broker commissions here because I can just see that if a seller has offered a credit and you have a scenario where the buyer is paying their own buyer broker, which we may be seeing more of those, and the buyer wants to use part of that seller credit to pay their buyer broker commission. If we weren't specific that that was okay, as the seller credit could be used for that, we could see a problem arising as a result of that, and an argument getting into, wait a second, is that buyer's closing costs or not? Because if you Google that out on the internet, you'll see, some places say it's not a closing cost. So that's why we added it here, because we do see buyers may be paying more buyer broker commissions, and if the seller has agreed to do a credit, then we'd like for that to be open to be used for buyer broker commissions. And then this next section applies only if the buyer is obtaining a loan for the purchase of the property. So in the event that the buyer is obtaining a loan for the purchase, any amount of seller credit disallowed by lender, meaning that the lender will not allow the credit, because the lender will only allow so much credits, is going to be handled one of two ways. Now, the way it's currently written in this form, both 5142 and 2101, which is the price modification form, the way it's currently written is the default is that anything that's disallowed by the lender will automatically result in a purchase price decrease. And you're going to fill out the 2101 to decrease the purchase price. But I've had a number of calls on the hotline where the seller won't agree to that. The seller will say, fine, I'll do a seller credit. But if it's disallowed by a lender, then I am going to, I'm not going to reduce the purchase price as a result of that. I'm just not going to do it. And so brokers have been writing that language up in the repair section or above this section, anywhere they can find, write it on the form, that if it's disallowed by the lender, then there will be no price reduction and they just lose the money. And so we have changed it to for checkboxes here so that the parties can select or agree to what will happen. If it's disallowed, it will reduce the purchase price, and then the NMAR 2101 would be used. And this reference to 2101 is in the resolution addendum. Obviously 2101 is the price reduction. And then, or it will not reduce the purchase price, and sellers shall not be required to pay any amount of the seller credit disallowed by lender. So it'll just be lost, right? It'll just be lost. So of course, that's not what the buyer is going to want to do. But evidently there's enough sellers and buyers are agreeing to it because they're signing off on these. So we've changed the form a little bit. We also have a buyer broker termination agreement in here. So I know one of our members has been waiting for this for a very long time. I don't think she's on this call, but Linda, here it is. I told you we got it done. So it's a buyer broker termination. If you've entered into a buyer broker agreement and you want to terminate that buyer broker agreement, then we have this form. And, I think we're going to modify the 1106 termination agreement a little bit too, just so that I feel like that form's a little confusing. I find it confusing, so I don't know if anybody else does, but I do. So number one is conditional. The parties hereby agree the early termination of the buyer broker agreement. It's effective whenever date you put it in there, upon the below conditions, explanation of any conditions for early termination. So for example, I showed you a buyer, I brought a buyer to the home, and if they come back and they buy within the original term of our buyer, or excuse me, I showed you a property. If you end up buying that property within the original term of our buyer broker agreement, then you're still going to pay me under the buyer broker agreement if I can't collect it from the other side, right? So that would be something you would put in one. Unconditional. They agree to unconditionally terminate the buyer-broker agreement. Neither party shall have any further obligations. And then we have the protection period still applies. So in the event that the buyer has agreed to compensate the broker in the buyer-broker agreement, the protection period allows for the broker to collect a commission from the buyer after the termination. It's that whole language that we have in there. And notwithstanding the foregoing, which means anything ahead of this or above this, you can just ignore. The protection period shall automatically terminate upon the buyer entering into a written exclusive buyer-broker agreement with another licensed real estate broker. We talked about that when I was talking about it. But here we're saying that the protection period shall begin upon the full execution of this termination addendum and shall terminate so many days after the full execution of this termination addendum or the date the protection period would have terminated under the original term of the buyer-broker agreement. So in other words, if there's a protection period that you still want to apply, and that's the still apply right here, is it going to start? Because you have to remember your protection period begins when your agreement ends, right? So that 90 days or 180 days or whatever you guys put in there, it starts whenever it ends. And now we're ending this thing early. So are we saying that the protection period is still in place? And if you should buy within a certain period of time after the full execution of this addendum, I'm still going to get paid? Or are we saying that the protection period that was originally established under the original agreement, which is 90 days, 180 days from the original term date, the end term date of the agreement, is that the appropriate time frame for the protection period? And then we have, if it no longer applies, you put it no longer applies. So now we have a termination agreement for the buyer broker agreement. You guys both have to agree, both the buyer and the buyer's broker have to agree to enter into a termination agreement. Again, it's a contract, so they can't just take off, and neither can you. If they materially breach the contract, if they're doing things over and over again that make it impossible for you to represent them as a buyer's broker under the buyer broker agreement, then you may have grounds to unilaterally terminate, depending on what it is, but that's going to be looked at on a very case-by-case basis. I encourage you to keep copious notes if that's where you're going with it. For example, you're working with a buyer broker who is constantly looking at properties without you, talking to other brokers all the time, perhaps making offers on properties kind of behind your back, so to speak, even though you're supposed to be working with them, and this goes on, and you've had conversations with them, you've documented those conversations, and you just decided you don't want to work with them anymore because they're not adhering to any of your agreements. Then again, full documentation, it would have to be analyzed on a case-by-case basis, whether or not you could just throw up your hands and say, I'm done with you. I'm not representing you as a buyer broker anymore. So that would have to, again, be analyzed each time. I just wanted to mention, I'm getting into some cases, additional cases. I kind of wanted to talk about those big cases before we got into the changes to 1106 and 1206, because those were related. But I did want to just mention a couple of other, I'm going to mention this national case, and then we're going to talk about some local cases from other states. So this one is a challenge to the clear cooperation policy. And as you guys all know, a number of years ago, NAR required, again, all realtor-owned MLSs to adopt this clear cooperation policy that says within 1 business day of publicly marketing a property, if it's a residential property, it has to go into the MLS. And public marketing is anything from putting a sign in the front yard to posting it on your social media page, whatever it may be. If you're talking about it outside your brokerage, you're publicly marketing it, and it has to go into the MLS within 1 business day. And this is, again, residential properties. So this PLS it's a listing network for real estate brokers. You can join it, and then you can post your listings on there for other participants in this listing network, private listing network, to see your listings. And you obviously couldn't do that with clear cooperation. You couldn't just put it on this private listing network because you have to put it in the MLS. You don't have the option of just putting it on this private listing network. So they brought suit, and they said that it was a violation of the Sherman Antitrust Act, and they brought suit against NAR as a result of it. And this has been going back and forth because it was dismissed at the district court level. It went on appeal. The appellate court overturned the lower court's decision, so it went back to the lower court again. But it looks like there has been some settlement of some sort. So 3 of the nation's largest MLSs brought this suit was brought against 3 of the largest MLSs, and all of them except for NAR have settled. and NAR remains in this. So the filing requested the court stay all the deadlines pertaining to the settling defendants to allow the settling parties to finalize the draft agreement, and that was granted. So they're not, the case is not moving forward as to all of the defendants, the settling defendants, the ones that have entered into it. We don't know exactly what that settlement agreement looks like. I don't really know what it could look like, honestly, because again, the clear cooperation policy says that you got to do it, right? And if these are realtor-owned MLSs, they're supposed to adhere to the NAR rules. And I can't imagine that this settlement agreement doesn't allow them not to put it, doesn't say that, hey, yeah, you can put it in this private listing network, but you don't have to put it in the MLS. So I don't know what this settlement agreement looks like. It might turn clear cooperation on its head, and we'll have to see once this plays out a little bit more where this goes. But NAR remains a defendant, so they will be going to trial unless they settle something. But so far, NAR's not been settling anything. So let's just talk about a couple of cases in some other parts of the nation that are happening. We are a sparsely populated state, so we often look to other courts in other jurisdictions to see what's going on. And these are a few cases from other jurisdictions. So in 2016, a landlord executed a broker agreement with a brokerage firm to find a tenant for the landlord's commercial property, and the contract promised the broker a commission based on the lease value. And the broker secured a tenant, and a cooperating broker also employed by the broker represented the prospective tenant in the transaction. So we're talking dual representation. Broker thus acted in a dual capacity, representing both the landlord and the tenant. The brokerage agreement between the landlord and the tenant included a form disclosing the broker would act as a dual agent for the transaction that substantially mirrored the DC Brokerage Act's model form. Evidently, they have one in their statutes, a specific model form. But the spaces on the form for the client and broker's name and the signature lines for both parties were left blank. Despite the incompleteness of the model form included among the materials, the brokerage agreement between broker and landlord, the 12-year lease agreement executed by the landlord and the tenant, a provision memorializing the broker's representation as dual agent, all of this stuff. So even though the form was not completely filled out, there were a lot of other documents that kind of, made it very clear that what the agreement was between the broker and the landlord. And so those were all introduced during the court. And following the execution of the lease, the landlord failed to pay the broker $750,000 in commissions pursuant to the brokerage agreement. So, of course, the broker filed a one-count lawsuit in the U.S. District Court and saying that the landlord breached the contract. The lower court moved for summary judgment, arguing the broker was not entitled to the commission due to its failure to adhere to the required formatting specifications. Remember, they didn't sign it, they didn't have their names in it, they didn't fill out the form properly. The DC court agreed and granted summary judgment to the landlord, finding the broker failed to provide the necessary disclosures for dual representation, relieving the landlord from having to pay the commission. The court highlighted how the statute detailed provisions reflected the lawmaker's intent to guard against fraud and deception. However, the broker appealed the decision, and on appeal, it was reversed. And there was a decision to award judgment to the landlord. The decision to not require the landlord to pay was actually overturned. And the DC court explained that despite failing to adhere to the code's formatting specifications, the broker will have the opportunity to prove entitlement to the commission by showing whether it fulfilled the Broker Act requirements of obtaining truly informed consent following disclosure of a dual nature. So they're going to send it back to the lower court, and they're going to let them go ahead and argue and introduce all that evidence that I talked about a minute ago, all of those agreements and emails and everything else about whether or not there was really informed consent and an agreement for this landlord to pay. Both of those two things were required out of this. So unlike the DC case where there's a statutory form, obviously we don't have statutory forms. We have NMAR forms, which, by the way, I'll say about NMAR forms, nobody requires you to use NMAR forms. I hear this all the time, that you are required by your E&O carrier to use an NMAR form. You're required by the Real Estate Commission to use an NMAR form. You're not required to use NMAR forms. I will also tell you that there was a case a number of years ago where a consumer felt like the form that they were used, which was a state promulgated form, didn't protect them very well. And so they brought suit against the broker who had had them use the form. And the court said that the state association who promulgated the form, because they were also named defendant in that lawsuit, they said that the state could not be found liable because the state didn't make that party use that form. It was made available to them, but the state didn't require them to use the form. And we don't require you to use NMAR forms. However, the court also said that the consumer had a case against the broker because the broker is the one who provided the form. Now, in that case, that may or may not have worked out for them. And I don't know actually how it worked out for them. They might have settled something. And I'm not saying that the form was deficient in some ways, but I do say that we take great care in making sure that our forms are very protective of not just the consumers in the transaction, providing protections for the buyers and the sellers, but also for you guys. So if you're not using NMAR forms, I caution you in the form that you are using. If it's drafted by a real estate attorney, of course, I'm not concerned. But if it's some other form that you've pulled off the internet, yet would you have E&O for that? Yes. Is the commission going to prohibit you from using it? Is NMAR going to prohibit you from using it? The answer is no. However, if you're not using forms that have been vetted, like the NMAR forms have been vetted, then you do subject yourself to the potential of liability and risk, right? Because you've put that form in front of your consumer and said this is a good form. So just be cautious. So we have a statute in New Mexico that says that prior to writing or presenting offers, a dual agent shall obtain written authority from the buyer, client, and seller client in the form of a separate dual agency agreement. In that case, like I said, there were two issues: whether or not there was informed consent of the dual agency, and then whether or not there was sufficient evidence to determine the landlord had agreed to pay the broker, even though they did not fill out that form correctly. On the first issue, the issue of dual consent, I've talked about how we've dealt with that dual consent issue. But in New Mexico, and I know we don't work as agents in New Mexico, except if you are working in a landlord-tenant context, because if you are a property manager, you are. You can work as a leasing agent or as a tenant's broker without creating agency automatically. So you can work as a transaction broker. But in New Mexico, if you try to create dual agency in New Mexico, the law of New Mexico is that there's no such thing as dual agency, which I completely agree with them on that. You cannot be representing both parties as an agent and fulfilling all your duties, your fiduciary duties to both parties. So what the law says is that you turn yourself in to a facilitator. So if you have a representing a seller or a buyer or a landlord and a tenant in an agency capacity on both sides, then you have just destroyed dual agency and you've turned yourself into a facilitator. And then of course that begs the question of what duties does a facilitator own in New Mexico? And even though it's not specifically spelled out in New Mexico, I believe that they owe the totality of the broker duties to both parties on both sides of the transaction. So it's like a dual consent scenario. You're working on both sides of the transaction. Because there's not a lot of clarity in the law about whether or not the dual, what a facilitator specifically does. But again, I opine that it's both the totality of the duties on both sides of the transaction. In this particular case, in July of 2020, plaintiffs and two co-applicants submitted an application seeking to rent the defendant's property, and the rental advertisement included no dogs notice. However, the prospective co-tenant submitted their application along with information requesting permission for the 50-pound terrier mix, described in the email as a verified emotional support animal covered by the ADA. The landlord explained that all dogs, including service dogs and emotional support dogs, were not acceptable. The applicant did not communicate detailed information about the plaintiff's diagnosed mental and physical impairments that qualify as disabilities under the ADA. Emails also included additional references to the ADA Act. However, ultimately the landlord said that we will not allow the dog, and the tenant plaintiff ended up suing the landlord. To prevail on a claim alleging the failure to reasonably accommodate a tenant's disability, the plaintiff must prove the housing provider knew or reasonably should have known of plaintiff's disability, and the reasonable accommodation may be necessary to enjoy the rental, and the defendant refused to make the accommodation. Those are the requirements of that first paragraph. In October of 2021, the District Court for the Central District of California awarded summary judgment in favor of the defendant, the landlord, because the correspondence providing information about the dog could not support a finding that the landlord was aware that the tenant suffered from a disability. And the court found descriptions of the dog as a registered and verified emotional support animal, established merely kind of an degree of an illusion of it, but it didn't actually come out and say, hey, I have a disability, I need this animal. But on appeal, the Ninth Circuit, and by the way, we're here in the Ninth Circuit, reversed and remanded for further proceedings, stating that knowledge of an applicant's disability status can be actual or it can be constructive. Therefore, a dispute still existed whether the emails provided enough evidence that the landlord should have known of the applicant's disability without them actually coming out and saying exactly what they had going on. The court highlighted the parties' use of phrases such as reasonable accommodation, discrimination, and service dog as significant evidence of potential knowledge, even though, again, the tenant never came out and said, this is my disability. So the parties stipulated to a trial on the briefs, which means they didn't go to trial. They made arguments in court, they filed briefs or written documents, and they said, we stipulate to you making a determination based on what we have submitted in writing to the courts. And after considering the relevant evidence, the court granted the judgment in favor of plaintiff, ruling that the defendant failed to reasonably accommodate the applicant's handicap. So they felt like those key words, those are the words you're listening for, were enough to put the landlord on notice that this person had a disability that would qualify under ADA. The court found the defendant's denial of plaintiff's application violated the Reasonable Accommodation Act, along with the California Act, and he was in breach, and in violation, they awarded him $14,800 in compensatory damages based on out-of-pocket losses sustained in securing an alternative housing. Plus, he was out all the money he had to spend for defending that lawsuit. An appeal was filed by the defendant on April 26, 2023, and it is currently pending. So in the event that you guys have any property managers out there dealing with this subject matter, I get questions about this constantly. We have an information sheet in the library, form 6111 talks all about emotional support animals and the kind of documentation you can request from the tenant. And I encourage you guys to review that form if questions come up. Takeaways: promptly to request for reasonable accommodations, follow the U.S. Department of Housing's guidance. And again, that's all incorporated into that 6111 that I talked about. Remember that emotional support animals, service animals, they are, first of all, there's no distinction in landlord-tenant law between an emotional support animal and a service animal. So a service animal can be a dog and it can be a small horse. That's kind of weird, huh? But still, it's just, those are the only two animals that can be service animals, and they have special training. An emotional support animal can be anything, and it doesn't have to have any special training, but there is no distinction in the law between these two things. The other thing that's important to remember is that these are not pets under the law. So if they actually qualify as emotional assistance animals or service animals, you can have a no pet policy. You can have a policy that demands additional deposits if there are pets in the property. You can have, size requirements. You can have breed requirements for pets. You can't apply any of those in a scenario with an emotional support animal or a service animal, because they're not considered pets on any level. Okay, so all of those rules you have with pets go out the door. If you have a one pet policy and they have one pet and one emotional support animal, they are in compliance with your policy, right? So you have to allow the two of them because they're not pets. So just be very careful about that. You can deny specific pets or specific emotional support animals or service animals if they are aggressive and you've seen them, or they've demonstrated to other tenants, for example, that they have aggressive behavior, or they're destructive, or they're, but it has to be specific to that animal, and it can't just be, we don't allow this type of breed, or we don't, allow this size of dog, or those kind of things. It has to be, I can't allow that particular dog because of things that I know about that dog, and be ready to support your denial. If an individual's disability is not really apparent or known, engage in a good faith dialogue, right? Those were key words that were being said by this tenant, but the landlord didn't end up engaging in a dialogue about it. If necessary, request reliable information verifying the disability and the need for the assistance. The 6111 talks all about that verification. Be aware that refusing a reasonable accommodation for an animal is permitted if the animal poses a direct threat. I talked about that a second ago, that cannot be eliminated or reduced by the individual controlling the animal. Recognize that communications using phrases such as reasonable accommodation or references to the ADA could trigger that requirement, that accommodation requirement, even though they haven't come out and say they have the specific disability. In this case, the plaintiff, a Massachusetts broker, claimed, and this is in Massachusetts, obviously, claimed that in 2016, an oral exclusive buyer's agency agreement was made with the clients. The parties agreed she would be the exclusive broker for 1 year for their new home purchase, with a commission upon purchase. Further, the clients agreed to refer all potential properties to her and inform other brokers of the exclusive relationship. The broker showed the clients at least 10 properties and provided other financial and analytical services. Although the plaintiff performed substantial services, the plaintiff being the broker, pursuant to the contract between 16 and 17, the clients identified a home on their own, That never happens, right, you guys? Where the broker wanders off and identifies a property on their own without notifying their broker that they've been working with. Or notifying the listing broker that they had an exclusive buyer's agreement. The client purchased the home using another agent of the listing broker's firm that represented the seller. And after purchase, the clients terminated their relationship with the plaintiff, their former broker, via email, recognizing the work she did for them. Thank you so much, and sending her a gift card from Amazon. Not sure that was enough, but obviously not, because here we do have a lawsuit, right? Plaintiff subsequently brought a suit claiming the client's breach of their verbal agreement was enforceable and the broker was entitled to compensation as expected damages. The lower court granted the defendant's client's motion for summary judgment because there was no written agreement. So there's no written agreement. We're not going to enforce this oral agreement that you guys had. The appeal court vacated the summary judgment, recognizing the statute of frauds was an express exemption for contracts involving compensation, has an express exemption for contracts involving compensation for real estate services. So the statute of frauds is a legal doctrine that says certain types of contracts have to be in writing and signed by the party. It's a general, statute of frauds is a general concept in the law. But there is an express exemption for contracts involving compensation for real estate services. It further concluded that the remedy for the breach of the exclusive real estate broker's contract, like other contracts, is the payment of the compensation. And the case was further appealed to the next higher court, the Supreme Judicial Court of Massachusetts. The Supreme Court granted further appellate review to clarify the limited issue of available remedies involving the breach of an exclusive real estate broker agreement. And the Supreme Court of Massachusetts, if the court affirmed and the court declined to adopt a rule requiring that the contract contain a clear statement that the broker is entitled to receive commission, regardless of whether the broker played any role in effecting the desired sale or purchase, in order for the broker to recover damages. It held that the expected compensation as damages was appropriate because the plaintiff is entitled to the benefit of that bargain and should be placed in the position she would have obtained had the contract been fully formed. So she won. The broker won this. And I think that's, and it continued. It's additionally, there was an assistance by the state association, who has filed what's called an amicus brief in support of that broker. The court distinguished opposing case law involving bare-bone contracts and analyzed the industry's transition from an agent, sub-agent bygone era to a modern practice of buyer's agents entering into exclusive listing agreements that include defined obligations placed on both parties. And the new market realities combined with internet and ubiquitous display of such listings. I mean, this is happening all the time, right? Where you're working with a buyer and they wander off because they find something on the internet that they liked. The case was remanded to the Superior Court, where plaintiff's breach of contract claim may proceed against the former client. So they're going to go back to the lower court to determine it, but it wasn't going to be dismissed strictly because it wasn't signed off on. Takeaways at the outset: establish the nature of the relationship with the parties. Listing brokers, buyer broker agreements establish those relationships. A written representation agreement will ensure broker is compensated for their services, and having a written representation agreement with specific terms promotes transparency and helps minimize disputes with the parties. But what I also want to say, again, in New Mexico, is that would not play out like that here. Because in New Mexico, we have a very specific statute that says that if you want to get paid by a consumer on the buyer side or on the seller side, you are going to have something in writing signed by that party. And if you don't, you're not going to get paid. Okay. So this goes back to the buyer broker agreement and the seller broker agreement. So even though I just went through a whole case that would not play out the same way in New Mexico, it gave me an opportunity to explain to you guys that it would not play out like that in New Mexico, or it was highly unlikely it would, because we have a law on the books that specifically requires that any agreement for a buyer or seller to pay you be in writing and signed by the party. So again, encouraging buyer broker agreements and listing agreements. The other thing I want to just say about this, you guys, and I think this is going to become huge in the market. We all know that the Code of Ethics does not allow you guys to interfere with a written agreement that a consumer has with another broker, another realtor member, right? It is also an obligation, a broker-to-broker obligation provision under the New Mexico Real Estate Commission rules. If you guys just send a buyer-broker agreement over to a buyer and say, here, sign this, they probably don't know what they just signed. Let's just put that out there, okay? They probably don't know what they just signed. And we're going to be seeing a whole lot more of that with these buyer broker agreements. So you guys are going to start using them more because you've come to this class and you recognize the importance of them. But if you aren't having the conversations that you have with your sellers on the buyer side, they're not going to know they signed that. And if they don't know that they signed it, then it's number one, not going to protect you very well. And number two, it's going to create all sorts of issues when they go work with another buyer broker, right? So listing brokers and other buyer brokers, you guys are going to have to dive into this more than you've ever had to do so before, right? You are going to have to go into these things assuming there's a buyer broker agreement already in place with this buyer you're talking to. And you are going to have to dig a little bit to make sure that that's not the case. And you on the buyer side, when you're getting these things signed, make a big deal. You bring balloons and maybe a cake, to the signing of your buyer broker agreement. You emphasize what it means to have a buyer broker agreement and that exclusive relationship that they've said they have with you, right? You are their one and only, buyer broker. You make a big deal about this stuff so that they understand what they've just signed, because this is already coming up. This is already coming up. I've had probably 6 phone calls on the hotline where buyer brokers have entered into buyer broker agreements and their buyer has wandered off anyway and worked with another buyer, made an offer on a property, and they've gotten cut out of the deal. You have a contract. Yes, you can sue on your contract. But I feel like the problem with, electronic signatures are great, except for nobody knows what they're signing. So you guys just make a big deal about it. Like I said, have the same big conversation you have with the buyers that you're having on the listing side when you're taking a listing. You guys put together these great listing packages, you go over there, you make a big deal about it, and they're fully aware that they are, maybe it's because the sign's in the front yard every day they come home, right? But they're fully aware they signed a listing agreement with you. Make sure you're making big deals about signing buyer broker agreements so they understand what they've signed and what they mean. A couple more cases. Beginning in April, defendant entered into a lease agreement with a property owner to rent commercial space, and in 3 years later ceased operations, returned keys to the owner's daughter. So the tenant moved out, returned keys to the owner's daughter, and vacated the property before the April 2019 lease date. So it was like another 8 months before the lease ended, but they vacated. Despite leaving, the lease remained in effect. And the landlord continued fulfilling, or the tenant continued filling their financial obligations. So they kept making their payments on their lease. In September of 2018, the property was purchased by another buyer, becoming the new landlord under a still effective lease agreement. Before the purchase, the new buyer acknowledged that the tenant had vacated the property and confirmed that no other party had access or possession. So they knew it was vacated. Then between January 31st and February 1st of 2019, there were extremely low temperatures in Wisconsin, caused the pipes to burst at the property. The damage impacted the building to the extent that it ultimately needed, oh no, how do I go back? Oh no. And that was a big takeaway. Sorry guys, I didn't mean to go back. Anyway, the pipes bursted, and as a result of the pipes bursting, there were thousands and thousands of dollars worth of damage. I mean, it was really incredible amount of damage that as a result of this pipe bursting. So yeah, I wanted to see the amount of it was pretty incredible here. The damage prompted them to sue the insurers. Did it say how much it was? I just remember the amount was crazy. The damage prompted Lynn to sue. So the buyer ended up, the new buyer who owned the property ended up suing the tenant, who was still had a lease agreement in place, for failure to maintain the property. And despite an operative and effective lease agreement requiring the tenant to maintain the gas and electric utilities, the Wisconsin Federal District Court granted summary judgment in favor of the vacated tenant. So it said that the vacated tenant was not responsible. So I thought I had a slide on the amount of money that it cost on this. It was an incredible amount of money. It was something like, $80,000 or something really extreme. So anyway, to be sure, the takeaway from this is be sure to understand lease obligations or responsibilities of parties when purchasing and vacating, as applicable to confirm any voluntary surrender in writing and ensure proper written communication is received acknowledging the surrender, and consider using estoppel certificates to verify operations and the status of lease agreements. So anytime you are going into a property, purchasing a property, whether it be commercial or it be residential, you guys are wanting to make sure that you use the estoppel certificates. The residential purchase agreement references the tenant occupied property addendum. Always use that form, you guys. I've had situations in the residential context where you enter into a purchase agreement and it's a tenant occupied property, and the buyer understands what the tenants are paying and maybe their short-term leases. They kind of make decisions based on what they're paying and how long the lease agreements are in place. And then because the tenant occupied property agreement isn't used before the sale of the property, the closing on the property, the landlord or the owner of the property, the seller, changes the lease agreements. They enter into long-term lease agreements. They give the tenant some, really great deal for the next 3 years. Now, you can end up in litigation over that, of course. The buyer could take issue and say, hey, this is not the same condition it was in at the time, if they find out about it before closing. But our tenant occupied property addendum is very specific that you can't make those changes to lease agreements after the buyer has gone under contract without the buyer approving those changes, because again, the buyer might be, basing their decision to buy the property based on what they know about the lease agreements in the moment. If those change, you got to let the buyer know about that. I think I have one more case, and I just wanted to mention this. It's a very short case. It was an ADA issue. So I've talked to you guys in the past a number of times about the ADA and making sure that your websites, for those of you who have websites, are ADA compliant. In this particular case, the guy who brought the lawsuit was a tester. So they were just going around to different websites to figure out if they complied with the ADA. And if they didn't, they were bringing a lawsuit. In this particular case, the court said, as a tester, we're not going to allow you to bring a lawsuit. You're not actually somebody who's trying to utilize the website and is unable to do so because it's not ADA compliant. So in this particular case, you are foreclosed from bringing any kind of lawsuit because you're not really an ADA person. You're just a tester trying to find these violations. But the reason I bring this up again is because if you have a website, a public-facing website, make sure it is ADA compliant, because if this person had actually been an ADA person, somebody who qualified under the act, and they couldn't access the website, they would have a case under the rules. So make sure that you guys are familiar with the Department of Justice's March 2022 guidance on web accessibility, or better yet, make sure your developers are familiar. Make sure that you're talking to them about making sure that you're ADA compliant. So if you put it together yourself, you may need to bring in a third party. If you actually are already using a website developer who's handling your websites, then just make sure that they're aware and that they are complying with making sure that your website is ADA compliant. This particular case, you guys, just got heard by a local district court about a month and a half ago. I actually will be talking to the broker to get some additional details on it. But it was a tragic, tragic case, and it's happened here in New Mexico. And like I said, it just went to trial at the district court level. And it was wintertime, and the listing broker had put a lockbox on the water meter on the side of the house or in front of the house, but on the water meter, not on the front door. And the water meter was located under a spout or off, under the roof, and whether there's a spout or whether the water was just coming off the roof. But wherever it was located, it was coming down off the roof out of the spout or over the water, off the roof directly or out of a spout, and it was freezing where the water was hitting because it was so cold outside. A buyer broker had notified the listing broker that they were coming over to the house to preview the house for the client. The listing broker was not present at the time this happened. The buyer broker went around to get the lockbox off of the water meter. They slipped on some ice, they hit their head, and they passed away. So very, very tragic loss of a realtor member under the circumstances. The estate of that realtor member brought a lawsuit against the brokerage, of course. I will tell you, this is another good time for me to remind you guys, Rice Insurance has these huge gaps in your coverage for property damage and personal injury. So there's no coverage in your policy if somebody should get hurt or someone should pass away or something is damaged on the property. So please have alternative insurance in place, because even if you prevail on these lawsuits, you are still spending a small fortune to defend yourself. So make sure you have alternative insurance in place. I have heard, and I know that the defendant in this case was not found liable and that's wonderful news that he was not found liable for the death of this broker. But I want you guys to take a couple of things away from this, and I'm going to get some more details on this. I'll be talking about this at the QB summit, but a couple of things that I want you to take away from this. Number one is that This is one case at the district court level in New Mexico, which means that this case could play out completely differently in another district court in New Mexico. So there's no precedence that we've gotten from this. Now, the estate might end up appealing the decision, and it will go up to the appellate court, and maybe we'll get some law out of the appellate court that will affect other district courts here in New Mexico. But what we don't want to take away from this is that we're safe to be putting these lockboxes anywhere where we want to put them, because this one broker in this one circumstance might have prevailed in this case. That is not the takeaway, because again, it could play out very differently if the fact pattern was just slightly different. It could play out very differently in another district court, even if the fact pattern was exactly the same as this fact pattern. And it very well might end up up at the appellate level, where they may overturn the lower court's decision. So we don't know how that's going to completely play out yet. So what I want you to take away from this is be thoughtful about where you're putting your lock boxes, right? Do not create scenarios that can create, because even if you win on this lawsuit, there's still a broker who's passed away as a result of this, right? So that just makes you feel awful. You don't want to be put in a position, want to put fellow brokers or obviously consumers, buyers, in a dangerous position when they come to look at your property. There was a case back east that I talked about in one of my earlier updates. And in that case, the buyer, not the buyer's broker, see, the buyer wasn't even present in this case. I think it was just the buyer's broker who was previewing the property. But in the other case back east, it was a buyer who slipped and fell on some ice coming up to the house and brought the lawsuit. And the listing broker wasn't at the property at the time. And in that particular case, the court said that the listing broker was not liable because they weren't in control of the property. It was another, snow situation, and they weren't there at the time. They weren't even on the property at the time. And so they made a big deal of the fact that the listing broker wasn't present at the time, and they might have done so as well in this one. I'll have to see if we can get a written opinion, or if it was a jury trial. But nonetheless, and we don't usually get written opinions at the district court level, but I'll see what I can find out. But anyway, the point being is that you are probably going to be liable to a greater degree if you have control over the property. So there was another lawsuit brought in Santa Fe from somebody who came to an open house. He said that the listing broker hadn't turned the lights on in the garage. So as he went down into the garage to take a look at the garage, he slipped and fell on the stairs, and the ambulance had to come and take him away, and he had damages, and he sued the listing broker and brokerage as a result of that. In that case, the listing broker obviously had control over the property, and the allegation was that she failed to turn on the lights. So if you have control, you're going to have a greater degree of liability, arguably. I mean, that's going to be the argument. If you're not even present at the property, especially when you're dealing with, things that you have no control over, like snow and ice and things like that, then that might mitigate your liability. But again, you don't want to do things to further create. You don't want to put a lockbox on a meter that's underneath a drain spout that could, where water could fall down and create ice and make it a dangerous condition to get that, or underneath a tree, or something that could create problems like that. So these are all things you guys need to be thinking about as from this case. And I'll get some additional details and talk about this case again in the future. And I'm sure, I'm pretty confident it'll probably go up on appeal. So there might be an appellate court decision that might come out of this. So we'll see. Let me see what kind of time I have now. It's 12 o'clock, but I know I got started a few minutes late. So I'm just going to talk about a few more things, and then we will be done for the day. I just want to mention about discriminatory covenants, because we have all seen these in deeds and old covenants. Some really archaic, restrictive covenants dealing with racial issues. Those have been, of course, they're completely unenforceable. I mean, we're all aware of that, right? That they're completely unenforceable. But the push is to try to get them out of these documents, so that they're not even, part of the public record. But that's been a little bit of a deal, because this goes back for years and years, and this is all part of the public record. So NAR is actively advocating for laws that address the presence of restrictive covenants in real estate documents, supporting efforts to document and address the continuing effects of those covenants. Many states, including New Mexico, have introduced bills to allow property owners to renounce discriminatory language in land records. And there's also been some talk about requiring title companies to basically rewrite those covenants when they come across them to remove any of the discriminatory language. And so, and there's also been a draft of model legislation that by the Uniform Law Commission, called the Unlawful Restrictions in Land Records Act, that's trying to address these issues on a national level, how we're going to deal with it and kind of get it out of the record. So there are some efforts being made. If you come across language like that and it highly offends your client, I mean, all you can really say about it is it's completely unenforceable. And there are some things that are happening to try to get the language out of these covenants and deed restrictions. Deeds restrictions are easier, obviously, because new deeds are pretty easy. Covenants can be pages and pages and pages of documents. So those make it a little bit harder, but there is some effort being made to address these issues, and you can let them know that. Unfortunately, there's nothing more you can really tell them right now about it because there's nothing that's actually been done. So if you're using endorsements and testimonials, I want to give you guys some quick tips on that and how to stay safe. God, I just realized I thought I had like a few more subject matters, but I actually have, probably about, 5. So I'm going to keep talking and you guys can drop off as you need to and when this is over. But I think I still have about 15 more minutes. So using endorsements and testimonials, online reviews from past customers obviously can be very powerful tool in promoting your business. But the FTC has recently revised its guidance, and it broadens the definition of an endorsement. In addition to the new guidance, the FTC is also cracking down on individuals and corporations that violate these guidelines. So endorsements and testimonials now include digital marketing, anything on social media, online reviews. The broader definition of endorsement now means any advertising message that consumers are likely to believe reflects the opinions, beliefs, findings, or experiences of a party other than the sponsoring advertiser. So that means not you, obviously, you're the sponsoring advertiser, but your customers. Section 5 of the Federal Trade Commission Act prohibits unfair or deceptive acts or practices in affecting commerce, and a violation of the act could result in civil penalties of up to $50,150. I don't know where they got the 150, but $50,150 per violation. So per endorsement or per review, that is not true. The FTC has already started enforcing the prohibition on unfair or deceptive acts against companies, including real estate brokerages. In 2023, the FTC and 6 states filed lawsuits against Roomster Corporation and its owner for duping consumers seeking affordable housing by paying for fake reviews. Separately, the FTC and the states filed a proposed order against Jonathan Martinez, who allegedly sold Roomster tens of thousands of fake reviews, requiring him to pay $100,000 and cooperate in the FTC's case against Roomster. The case is currently pending. I will tell you, I had this exact experience, you guys. I've had fake reviews on my website. I have a business, and I had a fake review on my website. I will tell you that if it's Google will do next to nothing about fake reviews. But it was really interesting. I did end up getting it off of there, but just because I found out who posted it and dealt with it directly. But I at the same time around that was happening, I got an email that said, we have people standing by to give you reviews and increase your Google rating. And I could not believe I received it. I mean, so I sent an email back and I said, do I understand you correctly that if I pay you a bunch of money, you will have a bunch of people write fake reviews so that my Google stars go up? Is that what you're doing here? I know you guys will be greatly surprised to hear that they never responded to my email, but they never responded to my email. But interestingly enough, I looked around, I started looking around at other websites, and, you'd see all of these, 1-1-1-1-1-star reviews, and then you'd see 50, 60, 70, 80 5-star reviews show up. And you think, how did that happen? Well, now I know how that happened. They took advantage of the offer that came through. And now the FTC is cracking down not only on the people that are writing the fake reviews, like Mr. Jonathan Martinez here, but also on the companies that are paying for the fake reviews. So no fake reviews. Ensure the endorsements are truthful and not misleading. Endorsements should always reflect the individual's honest opinion. When using client testimonials, clearly disclose the outcome for one client may not be the same for everybody, right? Not everybody gets the same thing. Disclose any connection between your business and the endorser, especially for paid endorsements, as required by NAR's Code of Ethics. Always present a true picture in your advertising. For endorsements by an organization, ensure that the endorsement fairly reflects the collective judgment over the organization and not just of a few individuals. Okay, so if they're talking about, this organization endorsing you, make sure it's not just one person from that particular organization endorsing. Okay, just a few hotline issues and we'll finish up. Brokers managing their own rental properties, co-marketing with other settlement providers, serving alcohol at an open house, occupancy agreements, and transferring brokerages. So on brokers managing their own policies, if QB is on this call, you guys need to have policies within your brokers that talk about whether or not that's okay or not. Is it okay for them to manage their properties if it's not running through the brokerage? Or is your policy say if you offer property management, services, do they have to run it through the brokerage? Have a policy on this. If you are not running it through your brokerage, okay, either because your brokerage doesn't do property management or because they give you the option of running it and you've decided not to, you have got to be so careful. And this goes for, this goes for not just property management stuff, but it also goes if you're buying and selling properties outside of your brokerage. It is so important that you not blur the lines, because when you blur the lines for the consumer so that the consumer doesn't know if you're acting as a broker or you're not acting as a broker, it not only creates liability for your brokerage if you're not running it through your brokerage, it also creates jurisdiction for the real estate commission. So you might be acting as a principal in the transaction, as a landlord, as a purchaser, or as a seller, or any of these things, not utilizing your broker's license. But if you blur the lines and make it look like you're acting as a broker, then again, you create jurisdiction so that if that person's not happy for you, they can run down to the real estate commission, file a complaint, and the real estate commission will look into it. And you'll say, no, I was just acting as a landlord, or I was just acting as a buyer, and I wasn't running this through my brokerage, and I wasn't acting as a real estate broker. But you've done things to blur the lines for the consumer, they're probably going to get jurisdiction over you, and then they can discipline you and your license, right? So for example, if you are not running things through your brokerage, you should not be using any kind of documentation that has your brokerage name on it. So don't use branded forms that have your brokerage name on it, right? Do not use branded rental and lease agreements. Don't give out your brokerage business card to your tenant. Say, hey, this is how you can get a hold of me. Here's my business card. Because it looks like the brokerage is involved. Again, creating liability for the brokerage and also giving jurisdiction to the real estate commission, because it looks like you're holding yourself out as a broker. Having your tenants drop off checks at the office, right? That's a problem, because again, you're blurring the lines. Giving out your cell phone or your business phone with a recording that says, hey, you've reached Bob with ABC Brokerage. Again, blurring the lines. So if you really are truly trying to keep this out of your brokerage and not utilize your license, you need to go the extra mile. Now, what do you have to tell the consumer if you are a broker, but you are not acting as a broker? You have to tell them that you are a real estate licensee. That is required. Whether you're buying, you're selling, you're leasing, whatever you're doing, you have to say you are a real estate licensee. That's all you have to say. You don't have to give them your brokerage name. You don't have to give them broker duties. You don't have to give them any other information. And when you start giving them those additional information, that's where you, again, you blur the lines and you start looking like a broker. So don't give them additional information. I had a broker say, I'm not running it through my brokerage. I'm not acting as a broker, but I gave them broker duties. Well, you've just confused that consumer and created liability for your brokerage. So be very careful with that stuff, you guys. Co-marketing. To ensure that each co-marketing, if you're doing any kind of co-marketing, when I say co-marketing, I'm talking about marketing with other entities, like other settlement service providers, for example, lenders or title companies or things like that. Here are some do's and don'ts. There's a lot more don'ts than do's. Do ensure that each co-marketing party pays its proper share of the advertisement. Each party's share should be based on the proportion split or the fair market value of any and all services conduction. So if you're splitting the cost of an advertisement, and you're taking up half the page and they're taking up half the page, you should be paying 50%, they should be paying 50%. Do ensure that the agreed upon marketing is actually performed and that any payment made in connection with the services is a fair market value, right? So you're not overinflating what you're paying or underinflating what they're paying. Remember that just because social media platform is free for users to join or post doesn't mean that all users of the platform, everything that offers has no cost. For example, there may be costs associated with the development of the advertisement. That's a cost you guys should be splitting. Be aware that of anything, no matter how small it is, and it doesn't have to be cash, can be considered a thing of value. And it could be quid pro quo, which means you do this for me, I do that for you, right? That's a thing of value. So be aware that those are things of value. Do include the word advertisement in a prominent location on each party's information included on the co-marketing materials. Do document procedures to calculate co-marketing charges or create a standardized rate sheet for fair market value for the marketing. Do consider maintaining written agreements of co-marketing arrangements to demonstrate compliance with RESPA Section 8, as well as federal and state laws and regulations governing your co-marketing efforts. Do ensure that the advertisements are distributed to the general public such as publicly facing, broadly reaching websites, and cannot be viewed as targeting specific consumers. Again, that gets you into discrimination issues when you start doing that. Do ongoing oversight of all of your marketing, right? To make sure that both partners are paying what they should be paying and that kind of thing. Do not enter into an arrangement with a co-marketing party without getting the necessary corporate authorization for such arrangement. So if you're doing some business with some title company, your EO is not necessarily the person that can enter into a co-marketing agreement for that company. So make sure you're talking to the right people on your co-marketing agreements. Do not directly or indirectly defray expenses that would otherwise be incurred by anyone in a position to refer settlement service provider. So if you are defraying expensive, and this is why, for example, a title company cannot offer CE credit for free. It's something that you would normally have to pay for as a broker. And if they're going to pay for it instead, then that's a thing of value that they're offering. It's a violation of RESPA. Payments by settlement service providers to a third-party real estate listing aggregator sites that reduce your advertising costs can create a direct RESPA violation. Same thing as I was just talking about. Do not require or allow your co-marketing party to endorse you exclusively or vice versa. Do not allow either co-marketing party to refer the other as a preferred service provider or a partner. Beware of any perceived endorsements such as likes, follows, repostings, tag pictures with one another, or other favorable commentary on referral sources pages, where the activity is conducted from your personal or your business account. And of course, remember that all your promotion of your business should be done from a business account and not your personal account. Don't enter into co-marketing arrangements before considering the implications of any other concurrent relationship you may have, lead sales, desk rentals that you might have with your co-marketing party. You have to think about how those play in. Don't direct any of your co-marketing efforts to specific consumers with whom either co-marketing party has a relationship or over whom either party has the ability to influence selection of a settlement service. Do not evaluate or adjust a compensation paid under an arrangement based on a capture rate. So how much actually comes out of it, right? Capture rate, which is a percentage of referrals that convert to actual clients. Do not allow one party to act as a third-party gatekeeper, to act as a gatekeeper when dealing with third parties. Both parties should have separate agreements with third-party marketing firms. Don't perform services for the other co-marketing party that are outside the terms of the agreement. For example, if a real estate agent and a lender are co-marketing their services, the lender should not incubate or cull leads on behalf of the real estate brokerage, and as that is outside the terms of the co-marketing agreement and is not a compensable service. Do not share the cost of leads generated through websites or arrangements. Each party must pay their fair share. Do not exchange anything of value with anyone. Again, going back to the RESPA kickback, even a $5 gift card with your title person can be a RESPA violation. I get a lot of questions about alcohol, serving alcohol, and where I'm talking about alcohol for associations or for brokerages, this applies to all of that. In addition to that, I also will talk a little bit about open houses because I get that question quite frequently. So if your association or your brokerage has a party of some sort, somebody drinks too much, they get into an accident, it creates liability for the association. If it's an association party, it creates liability for a brokerage. If it's a brokerage party, and we have also in New Mexico, we have social host liability in here as well. Approximately 32 states do, including New Mexico, making social hosts responsible for if something should happen, if somebody they serve alcohol to goes out there and hurts somebody else, subsequently injures another person. There must be a causal relationship between the serving of the alcohol and the injury to the third party. And an association, a brokerage, or even a broker under these scenarios could be held liable for serving at open houses. I mean, if it's a brokerage open house, obviously the association is not going to be liable, but the brokerage could be liable. And so, of course, could the broker, if you're serving alcohol at an open house and somebody drinks too much and they go out and they hurt somebody. New Mexico is one of a number of states that extends liability to third parties under the dram shot laws, and a dram shot law allows an injured party to seek damages from the person or establishment that served the alcohol to the person. And New Mexico is also one of a handful of states with the legal concept of social hosts, like I said. So most, it doesn't just apply to businesses. It can apply to you having something done, some kind of event at your brokerage, or if you do have an open house. There are some limitations on liability, which is good news. It does not exceed $50,000, but a lot of your E&O, your E&O and a lot of your insurance policies will not cover things involving alcohol like this. So just be aware that there may not be any coverage in the event that you should serve alcohol and somebody should get hurt. You might not have liability coverage. I encourage you to look into that. So of course, how do we really reduce or mitigate the possibility that this would happen? I know this doesn't sound like a whole lot of fun, but consider having an alcohol-free event, right? Because then nobody's going to get in trouble for alcohol. Ensure adequate insurance coverage. So of course, going back, review your insurance policies to determine what kind of coverage you have for the alcohol related. Get it in writing. An establishment where an event will take place should have its own adequate alcohol related insurance. So making sure that that's happening, of course, that's the safer route, is to actually you go have it somewhere else, not, at your brokerage firm, not at your association, not at an open house, but at a specific place that has coverage in place. Establishment where the event will take place should have its own alcohol related insurance coverage. And they will also have an agreement. They should have an agreement that you sign with them that indemnifies them, so that in the event you should get pulled into a lawsuit, since you have had your function at their establishment, that they're going to indemnify you, protect you, defend you, all of those kind of things. Let me move this so you can see the rest of this. So keep a professional bartender. That's in between you and your guests. So you can hire a professional bartender, and I encourage you to do that if you're having any kind of events at your brokerage. You can actually do that. Now in New Mexico, that doesn't completely protect you. You can actually still be held liable, but hopefully these trained bartenders who are trained to notice when people have had too much to drink, who can who can spot fake IDs and these kind of things, will mitigate the possibility that you guys are going to get sued. Plus they have insurance in place, right? So other ways you can curb alcohol consumption: you can have a cash bar, make people pay for the drinks. They seem to drink less. You can serve food you can have food, make sure there's plenty of food available, because food with drinks is a good thing, especially like the carbohydrates that soak up a lot of alcohol. You can, limit the number of drinks that they can have, so they have tickets or what have you, so that it's not an open bar where they can just have unlimited access to alcohol. Cut them off about an hour before you're ending the event, so there's a little bit of time between the drinking and the driving. And then don't announce last call, because then of course everybody will run up to the bar at that point and start grabbing a bunch of drinks. So there are some ways that you can mitigate your risk. Making alternative transportation available if possible. If this is being held at a hotel and you can provide rooms for your guests, that's even better, that you can do that. And keep employees in check. It's really important that employees are not drinking too much as well at these events that you have, whether again at your brokerage or at your association, because again, that creates liability for the brokerage and the association to have your employees drinking too much at these events and then going out into the world. That can create liability for the association. Okay, occupancy agreements. All I wanted to remind you guys about this very quickly is that if you have a buyer occupancy agreement, it is not covered by the Owner-Resident Relations Act. So a buyer moving into a property early is not covered by the Owner-Resident Relations Act. Our occupancy agreement does say on the buyer occupancy that you should only use it for a few days. But in the event that they're longer term occupancies, since the Owner-Resident Relations Act doesn't apply to those agreements, and our occupancy agreement is only like 2 pages long, it really is inadequate to cover an arrangement, a long-term arrangement between a buyer and a seller when a buyer is moving in early. It really is inadequate what we have. And if you use the residential rental agreement, then you run the risk of bringing in the entirety of the owner-resident relationship into that relationship between the buyer and the seller, even though the Owner-Resident Relations Act specifically says that when a buyer moves into a property early, it is exempt or excluded from the Owner-Resident Relations Act, which of course begs the question, well, what do I do if I have a buyer who's moving in months in advance and a 2-page occupancy agreement isn't okay, and I don't necessarily want that whole Owner-Resident Relations Act to apply to that scenario? What do I do? We don't have a form in the library for it. We don't have a rental agreement that applies outside of the Owner-Resident Relations Act. So in the future, we may very well do that, but the parties may need to have an attorney draft something if it's going to be a long-term occupancy, pre-occupancy by the buyer. And I encourage you guys to explain to them that, number one, this 2-page occupancy agreement is not a good agreement to use for anything more than a few days or a week beforehand. And number two, there's no body of law that applies to this relationship. So you need to have a contract drawn up that it really explains the parties' obligations during that period of time. Now, that's the exact opposite, and this is very, very important, of a seller occupancy agreement, because if a seller stays over after the closing, the relationship that has been established there is a landlord-tenant relationship. That means that whole body of law, that whole Owner-Resident Relations Act comes into play. And on our occupancy agreement, on the seller occupancy agreement, we have a link to the New Mexico Real Estate Commission website where they can see this big body of law that is now going to govern their relationship. So when you hand them an occupancy agreement, we do still have that in there for seller occupancy. And we say that it shouldn't be used for anything more than 7 days. And it's kind of an arbitrary number, though. The first time you see any kind of implied tenancy mentioned in the Owner-Resident Relations Act is at 7 days. So that's kind of where that number came from. We also figure that maybe not a lot of bad things could happen in 7 days. But that relationship, and this is what they need to understand, it becomes a landlord-tenant relationship when the seller holds over, and that whole body of law is going to come into play. So just be very sure you're making that clear to them, and they understand what they're getting into. I'm not a fan of occupancy agreements. I think on both sides they can create real problems. Transferring brokerages, you guys. If you are an associate broker moving to a new brokerage and you have listing agreements in place, the first place I'm going to send you is your independent contractor agreement, making sure, seeing what that says about whether you can take your listing agreements and your buyer broker agreements with you when you move to another brokerage, because that's where that will be dictated. If you can take them per your independent contractor agreement, we have in a form in the library, an assignment form 2103. You can use that to assign listing agreements and buyer broker agreements to the new brokerage. Now, the other party to those transactions or to those contracts. So in the case of a listing agreement, the other party would be the seller, and the other party in a buyer broker agreement would be a buyer. Those people are going to have to join on this assignment agreement. So the assignor is the brokerage that's assigning it. The assignee is the brokerage that is receiving it. And then the other party that you'll see on 2103 would be the seller on a listing agreement and the buyer on a buyer broker agreement. But you can assign those agreements over to the other brokerage if your independent contractor agreement allows for that. The question often comes up about purchase agreements. What if I'm representing a buyer and I don't have a buyer broker agreement and I'm transferring my brokerage? What happens to that? Well, there's two issues there. Number one, the buyer doesn't have any obligation to continue to work with that brokerage because they don't have a buyer broker agreement. So the buyer can go with you over to your new brokerage and nothing can stop that from happening. Nobody's doing anything wrong. The buyer can move over there, not a problem. But I'm guessing that your new brokerage that's taking on some of this liability and responsibility for this transaction is going to want some compensation, right? And usually that compensation is coming from the co-op broker commission that's offered in the MLS, whoever the procuring cause is. But you got to remember, the procuring cause was the brokerage that brought the deal. That was your old brokerage or your former brokerage. So is that former brokerage going to share any of that co-op broker commission with the new brokerage? Well, that's what MR Form 2504 addresses. It does two things. It creates a line in the sand for when one brokerage stops being responsible for that purchase agreement and one brokerage begins being responsible. And that's important in case something goes wrong. Whose watch was that? Was it the former brokerage or the second brokerage? And the other thing it does is it talks about how that co-op broker commission is going to be split. So that former brokerage is going to share that. If it is, you can set that forth in 2504. So you need these forms in the event that you're moving to a new brokerage and you have listing agreements, buyer broker agreements, purchase agreements that are in play. Like I said, listing and buyer broker agreements, whether you can take those are dictated by your independent contractor agreement. Purchase agreements, nothing keeps the buyer from moving with you. They can move with you, but there's some other issues that have to be considered. So consider those by using 2504. All right, let's see, it's for those of you who stuck around, I'm about 15 minutes over, but I greatly appreciate your time today, and I greatly appreciate your patience. I know we got off to a little bit of a rocky start, but I'm glad you stuck in there with me. And if you have follow-up questions on this, I know I'll get a list of questions from the chat if you guys put any of those in there, and I'll try to get back with everybody on those. And you also can email me at the hotline number or give me a call at the hotline number as well.